Let's kick off with Focus on Health Law. This is a presentation of the Law Office of Kenneth Haber, where the Chief Attorney at Law is Mr. Kenneth Haber. This week, Attorney Haber is accompanied by Attorney Ramesh Khurana of the Khurana Law Firm. He questions Attorney Haber on malpractice and the doctors, Part 2. Let's join these two attorneys.
Good morning. My name is Ramesh Khurana. I am an attorney at law in Maryland. I have a great pleasure this morning to welcome Kenneth Haber, who is a very renowned attorney having his office in Boyers, Maryland. Mr. Haber, welcome to our studios.
Thank you very much, Ramesh.
If you recall, Ken, in our last segment, we had discussed about the malpractice issues about which physicians should be concerned. And now we will discuss other aspects of this always present issues when there is a settlement. Now, settlement has been reached or there is an adverse verdict. So, what do you recommend in that kind of situation?
Well, the difficulty is at that point in time, the insurance company has to provide notification to all sorts of entities. They're going to report it to the data bank, they're going to report it to the licensing board. Once it goes to the data bank, it basically goes to the world, even though it's called confidential. It's not really confidential. We'll get into that. You may have to self-report because in all your applications for privileges at hospitals, for third-party payer provisions, where you want to be with insurance companies where they pay for the services you render to their beneficiaries, their recipients, you have to self-report. Sometimes you have to do it within a very, very short time period even. And if you don't, they can consider that a violation. The licensing boards can, and then they send you a notice saying, why did you violate your obligation to self-report? You know, we're not only going to be interested in why you had the problem with the malpractice, but now we're going to have to look into whether you have integrity, where you're trying to hide it or not from us. And often it's just the doctor's very embarrassed over the fact that he had an adverse situation. And the fact of the matter is if there's a settlement of $1, it gets reported to the data bank. It gets reported to the licensing boards. It's not fair, but it happens. The doctor has to be prepared to explain it and explain that he does have professional competence to the licensing board and to the third-party payers and to any other agency that's making inquiries, such as Medicare.
Can you talk about the requirement of self-reporting by a doctor within a short period of time? What is the short period of time, Ken?
It could be as little as 30, 60 days, depending on the licensing board. As far as your hospital privileges, it's whatever the hospital bylaws provide, and it could be a very short period of time, such as 30 or 60 days.
And this reporting requirement is for the data bank and medical board as well?
Well, you don't have to worry about the data bank because the malpractice carrier is going to report you. You have to deal with that.
Okay.
But it's your obligation with the licensing board, and by contract, it could be part of your bylaws where you have to report it to the medical staff at your hospital where you have privileges. It could be part of your contract with the insurance companies or any other third-party payer that you're involved in. You can end up losing one of these third-party payers, and that could cost you your job. If you lose a major insurance company in your area and you're employed by somebody, they may not want to keep you on because of the fact that they can't bill for your services to those people. So it can cost a lot.
Now, Ken, you talked about the data bank. Now, if I'm interested, like I'm trying to find out whether I should be patient of that particular doctor or not, and I would like to see like if this doctor has been disciplined in the past or what types of actions have been taken against him, can I have an access to the data bank?
Only if the doctor signs off on authorization. It's quote unquote confidential to the extent that the doctor doesn't sign off when it's talking about private parties. It's not confidential when it deals with the government. The reports go to licensing boards and it goes to the federal government, and they can get their information. But the fact of the matter is, when it's private parties, it can't be released except by authorization. When a patient wants to get the information, the doctor is going to say no. But if you're trying to get privileges at a hospital, you got to sign on the dotted line. If you want a third-party payer to accept you into their program, be on their panels, you got to sign on the dotted line. And that says that they get access to the data bank. And so it's, in that sense, very not confidential.
Oh, I see. So I as a patient cannot access the data bank, but because doctor is compelled to sign off for certain entities, certain bodies, only then they can access. So do I understand right, like without the doctor giving an authority to go into a data bank, nobody can look into the data bank?
Well, different government agencies
Oh,
can.
they can.
They
Okay.
can without the doctor's permission. But private parties such as the hospitals, such as third-party payers, they can't without the doctor's permission. But the doctor wants to be able to participate at the hospital with the insurance panels that they have to sign, or else they're not going to.
What about the medical licensing board?
The licensing board can get that information. You can be sure of
Do,
that.
do they have the prior authority to look into the data bank, or they can ask the doctor to give the authority to look
The
into the
licensing board?
Yeah.
The licensing board gets notice actually directly from the insurance companies normally. The data bank certainly sends out notice to them as well.
Okay. Now, when we are talking about access to the data bank, well, now what does that mean to your practice and professional status?
It means that if you're in the data bank for anything, it can be very adverse to your practice depending on what it says. If it says $1 that you had a settlement, very unlikely it's going to cause you great injury. But any sort of significant reflection of some sort of lack of professional standards, it can cost you dearly. And how dear it is depends on the demographics of your particular professional statuses or your professional specialties representation is in your area. If they need a lot of brain surgeons and you're the only one around and you get data banked in one case, no, the hospital's not going to dump you if they need a brain surgeon, neurosurgeon. But if you're a primary care physician, what's called a PCP, and there's an abundance of your specialty in the area, then the insurance companies quite often will become very, very selective on who they're selecting, and they may just well cut you out.
Oh my God, that means it has very serious consequences.
Yes.
Depending upon the situation.
Absolutely. It can deprive you of participation in the insurance plans that pay a lot of money at times. It can deprive you of participation in Medicare if there's an adverse judgment against you, depending upon the specifics. Nowadays, with all these contractors running around in Medicare, doing Medicare's work for them, they're just looking for ways of finding people that they want to target for their reviews, and that certainly, if it's not in their portfolio now, it certainly will be coming soon, I'm sure.
Oh my God, so it does have very serious consequences.
Yes, it does. The medical status, the medical dealings of the doctor is getting more and more looked at by Medicare. Both in combination with reimbursement and just in terms of whether or not they're going to keep the person in the programs because of his standard of practice.
Okay, now we talk about the problem and the issue. Now let's talk about what's the remedy to avoid this type of situation from arising. What can we do?
Well, try to bulletproof yourself as best as possible. And you say, well, how do you bulletproof yourself? Well, you try to get an insurance policy that gives you a right not to settle. That's one thing, because so often these settlements are nuisance settlements, and the insurance companies want to pay off in order so that they don't have the exposure. Not only the exposure as far as some sort of judgment, but the exposure in terms of having to pay for defense, and they don't want to have to do that. It could be a very little judgment that they're threatened with, but the fact of the matter is they could be spending much more in defense, and you'd want to get maybe a second opinion from an attorney as far as dealing with your insurance carrier. We've done that in the past, and we've helped people avoid having settlements, and cases have fallen apart. There's one I can think of specifically where the case fell apart after the insurance company thought that it might not be a good idea to incur the wrath of the doctor's own attorneys. If you have a good doctor-patient contract, the plaintiff's attorneys may not want to take the case, and if no one's going to take the case, then you're not going to get sued in the first place. Maintaining good relations with your patients. Good bedside manners go a long way in terms of helping avoiding getting sued. You don't like to sue a doctor that you like. If the doctor is abrupt, if the doctor is arrogant, that type of doctor is liable to get sued much quicker than the doctor who is compassionate and seems really connected to that patient. You need to follow up notices to avoid getting sued, so you make sure that your patient gets all the information that the patient needs. You can get specialists to take on the tough patients, so you can even send them to the university hospitals. There's a number of things you can do to avoid getting behind that bullet, and that's what you want to try to avoid. You don't want to be in a situation where the worst is upon you and then you say, what can you do? You want to try to be proactive and avoid that type of situation in the first place. And that's what we would recommend to doctors. And I can see that our time is running out, and I just really would like to thank you for having me here. And it's really been a pleasure to be able to talk to the doctors in this area and to be able to explain to them some of the problems that they're facing and how they could avoid some of these problems and how complex these problems truly are.
Now, I would like to thank you very much for coming to our studios and giving us tips like how doctors can avoid all those kinds of problems. The most important thing which I learned today is if a doctor is very helpful and caring for his patient, I think problem is not going to arise at all.
There's a good chance.
Then of course on the legal side there has to be a strong contract between the patient. I think that is significantly important. Again, thank you very much, Ken.
Thank you for having me.
I appreciate you're telling us and giving us some good tips, and we will see you next time in our studios.
Thank you very much.
Thank you.